is administrative law? We talked about it in the very first session, long time ago, way back 3 weeks ago. What is administrative law? Go ahead.
Are there rules and regulations that apply to maybe like an administrative staff?
That's exactly right. In both state, federal, and local governments, we have agencies which make rules. Rules are law. Rules allow us to have our various types of specialty needs taken care of in the United States. There are several types of law that are made inside administrative agencies. We'll talk about how that law comes to be shortly. But the first thing that we want to talk about is an executive order. An executive order is issued by the president or by a governor or by a mayor. Any chief executive of any large elected body. That body must be an executive body. It lasts only as long as that chief executive is in office. So, any of the executive orders which our current governor has written during his term of office here in Tennessee will disappear the day that he is supposed to leave office. His successor will be sworn in, and that individual will be able to sign on to their own set of executive orders. Again, I pushed the wrong button. They have the force of law. They can be enforced by administrative agencies or by police agencies or any prosecutor or any individual who is responsible for enforcing the law because they are law. Temporary law, it's true, but they are law. They have to be renewed as soon as that new executive takes office or they disappear and are no longer enforceable. Have you ever wondered why, when you're watching the inauguration of the president, that the president arrives at the Capitol at 10 o'clock, but the inauguration and the swearing in is scheduled for noon? It's because he has a very small office in the Capitol building itself. It's called the Green Room. And they go in there and they sit there for 2 hours with all of his assistants and they just sign executive orders. Things that he or she wants to be in force as soon as they are sworn in as the President of the United States. Okay? That's why these orders are enforced almost immediately, and they have the force of law. Now, if there are any from the prior administration that they don't agree with and they don't want, what do you suppose happens to them?
Can you repeat it?
Trash.
Oh.
All the orders from the previous administration they don't agree with go right in here. It's nice to have something to show, to give you an idea of what happens with things. Okay? Well, how is an agency created? How is an agency created? Well, first of all, the Congress has to admit that it really doesn't know what's going on with this one body of law. That doesn't happen very often, does it? Congress does not like to admit that it does not know what's going on with something. For example, the Environmental Protection Agency. The Environmental Protection Agency is made up of specialists. Specialists who know what every phase of science, every phase of aquaculture, every phase of various types of environmental disaster that could occur, that could possibly be. And so the Congress says, since we don't know about this, we're not going to take any chances. What we're going to do is enact enabling legislation. And enabling legislation is that which allows someone else to do what Congress would normally do itself. And it's used in the creation of special agencies. They are executive agencies or independent agencies. You're on camera. Executive agencies are agencies which are part of the President's cabinet. They are part of the President's cabinet. So every time you look at a secretary of something, they sit on the President's cabinet and they have an agency for which enabling legislation has been created so that they can perform a special function. The President controls the budget for those agencies. So, when we have the Secretary of State, that is an executive agency. It's also an executive post sitting on the President's cabinet. The Secretary of State then has a function which the President himself cannot completely handle, which would be, begins with a D, second letter's an I. The function of the Department of State is diplomacy. Okay. An independent agency operates independent of the President. The independent agency is like the Securities and Exchange Commission. It doesn't sit on the President's cabinet, but it controls stocks, bonds, information on public corporations, all that sort of thing. The Federal Trade Commission, which controls trade between and among the states, and that people have to apply for licenses to do certain things. The Federal Communications Commission, which regulates our airwaves. These agencies are all independent agencies. They are funded by direct appropriation from Congress. Yes, Miles?
What about like the Federal Reserve Bank?
Federal Reserve is also an independent agency. The Department of the Treasury is not. It sits on the President's cabinet. But yours is, if you were the chairman. And we hope you will be someday. Okay? So that, and they only report, instead of having a meeting with the President every Tuesday, the way the cabinet does, they go before Congress every now and then, when Congress calls them in, to make a special report. Okay? So how does the agency begin to function? First, it has to adopt a body of law called the Administrative Procedures Act. It tells it what the rules of procedure. Remember, we said there are procedural processes in our first session that they have to go through in order to make law appropriate. Rulemaking is what an administrative agency works with. The first thing they do is provide a notice of the rule. So let's say we have a rule in the Securities and Exchange Commission that says, regardless of other federal law, public corporations will report their income and proprietary information to the commission on a quarterly basis. That's going to be the new rule. A notice of that proposed rule goes out and stays out for 90 days. And people, what that does is allows everybody to learn about it, absorb it, internalize it, and prepare to address it. Then there's a comment period. Now, the comment period is 90 to 180 days. The comment period means that anybody could write a letter to the commission and say, this is why I like this is why I don't like it. They can take it line by line and say, I would change this, I would change that, I would change the other thing. It goes in a set of huge files. Huge files, one for every commissioner on the Securities and Exchange Commission. Right? So that they will have access to that. After our comment period, we have what we call time to file interventions by interested parties. Now, there are going to be some folks, like public corporations, that are going to be directly affected by that rule. If they think they are going to want to continue participation on a very personal level, by being a part of all of the proceedings, even those that are restricted by judicial procedure, what they do is they file a notice of intervention. It's 2 lines. We, the undersigned corporation, by its directors, wish to intervene in this action named. That's it. That's all they have to file. Yeah,
Oh, so these days is like straight through, but it's like approximately 90 days.
These go right in order. So at the end of it, you'll see how long it takes for the entire rule to get through. So we have our interventions, and they have 60 days to do that. During each one of these points, the notice, the comment period, the intervention, nothing else happens with that rule. It just sits there. All right? Then they start having public hearings. Now, these are hearings that go all around the country. Everywhere there's a whole lot of big corporations that would like to say something or comment on this particular rule, they hold a hearing. So when the rule is so pervasive, like the rule I just stated, where they have to have corporations report every 90 to 100 days, they're going to take it to all the big cities, because that's where the corporate headquarters are going to be. So they're going to go to Atlanta, New York, Miami, Dallas, Chicago, St. Louis, everywhere there's an industrial base. Los Angeles, San Francisco, Seattle, all over the country. So they're all over the country, and they do this by 60 days. Some of us refer to these things as dog and pony shows. Because, you ever been to a dog show? They trot out all the pretty dogs and they get judged on how good they are, and somebody wins and somebody loses. Well, that's what's happening with all these people going out to all of these cities. They're getting up and they are, you're on camera. They are, you're on camera.
Just delete my part out.
Oh, okay. I'll delete yours. No, actually, it's pretty good. This is the best part of the class so far. And they come up before a hearing officer, and the hearing officer then allows them to talk. They don't have to put their right hand up and swear on the Bible or anything. They just get up at the microphone and it's like the comment period. They can get up and talk about whatever they want to talk about to try and influence the proceeding. All right? So that's the public hearing. And there are at least 3 of them. The APA calls for at least 3 of those hearings over a 180-day period. So we're saying every 60 days there's going to be a hearing somewhere. And then all of the results of those hearings, because they're all transcribed, are put into the big binders for each one of the commissioners, and they go into the record. So if there are 6 hearings going to be held, how long does it take for the hearings to conclude? 360 days or 1 year approximately for 6 public hearings. Are you starting to see why it takes so long to get a rule through an administrative agency? So we have a year and 60 days, another 240 days, a year and 240 days. You've got 2 years now so far, approximately. Once we have the public hearings, then things get really fun. Everybody gets their lawyer involved, and they have what we call contested hearings among the intervening parties. Now, these are the intervening parties, the people that filed during this 60-day period. And they come up here, and they have contested hearings about that rule. And everybody, it's like a trial, folks. They get up, and they have their experts, who are experts in whatever that rule is supposed to be. So in case this rule, they'd have public information specialists, they'd have marketing specialists, they'd have, economists, they'd have finance professionals. So they get all these people up and put them up on the witness stand, and they have direct examination. And then the direct examination is cross-examined. So every witness has direct and then cross-examination. It takes a long time to do this. If there are a whole lot of parties, if there are 500 parties, everybody gets a chance to examine every witness from every party. Okay? So by now, most people have forgot what they're actually there establishing the rule for because it's taken so long. That was supposed to be amusing. Then, after the contested hearings where everybody's examined and cross-examined, we have a final comment period, which lasts about 60 days. And that really is abbreviated to 60 days. They just say people sending in more letters and more information, the things they heard during the contested hearings that they want to put into the record, they can do that. We'll cut it off in 60 days. So by now, the record for every single commissioner just about would fill this room. And the commissioners have a staff, and they follow every single thing that's going on. They send representatives to the hearings. They send people to all of the contested hearings. They read all of the interventions. They read all of the letters, so that at least one person on the commissioner's staff is an expert on this rule. So then the administrative body, which is all the commissioners sitting up on their big high desk in the hearing room, the formal hearing room, formally receives the report of their staff, which is the staff now is talking about not just their personal staff, it's the entire analytical staff for the agency. They receive their report. And it's a symbolic report receipt. It's not the report that fills the whole room. It's generally a binder, just a single binder, which is intended to represent the whole of all the files. And that is officially received and logged in, and they say, we're moving forward with this. The commissioners and their personal staffs then examine it and give it final approval, or turn it down and say, we're going to go again with this, all the way back to the beginning. And they can do that 90 days after they receive the report in the administrative hearing. And they usually have hearings for this purpose every Tuesday. Tuesdays seem to be a very popular day for hearings. So, 90 days afterwards, and you have a ruling. So what happens if you don't like the ruling? What happens if they throw it? Let's start with what happens if they throw it out?
Change like one line and bring it back up.
Change one line, send it back up, and it's appealed.
You gotta start all over.
And they start all over. Or if they just want to change one line in sentence, they have to send it out to all the interveners and get their information. And then lo and behold, it may come back and just be sent right out and say, okay, this is the rule. Or it may also, you can tell them about it later. Or they go back and start all over again. Now, by the time that we've gotten through all this stuff so far, it's been 3 years. Do you think they're going to want to start all over again? No. But then again, if it's important enough, they will. We did some, when I was with the General Counsel of Tennessee Regulatory Authority, we did rulemaking. And we had one rule, one simple rule, one simple line in one simple area to amend a rule. It took us a year. Because everybody had a different opinion of what was actually going on. The final rule is then published in the Federal Register and compiled into what we call the Code of Federal Regulations. Now, first, the Federal Register. The Federal Register is a paper. It's a cross between a newspaper and a textbook. And it's published every week by the federal government, by the General Printing Office, and it's sent out to various depository agencies around the country so that people can go in and just read what's new. And they actually have a guide that goes with it every week that says what's new. In fact, that's the title of it, What's New. And it refers you to the various volumes that are being put together of the Combined Federal Register. So the Federal Register appears in many libraries, including the Fisk Library up on the 3rd floor. Have you ever been up on the 3rd floor? Anybody ventured up into the rarefied air of the 3rd floor of the library? It's up there. It's back to the northeast side of the library along the back wall. That is almost entirely Federal Register. Then, when there's enough Federal Register put together with final rules, they publish the Code of Federal Regulations and put the new rule into the volume where it belongs. Every agency has a volume number. So if it's a Securities and Exchange Commission and it's volume 71, the new rule goes into volume 71, subpart 2, triple B, 65X, or whatever number they've determined it should be. Okay? And these rules then have the force of law, just like statute. Just like statute. Unless a court overturns it by having the rule challenged at trial. How does that work? Well, I'm glad you asked me that question. When somebody doesn't like the rule, or something happens where the rule is broken, and somebody's brought to court, then it gets adjudicated, and the judge will issue a ruling, and part of the ruling usually is that this rule does or does not fit the current circumstances. When that happens, part of the rule can be sustained, it can be modified by the court, or it can be completely disposed of and tossed out. And what happens if it's modified or tossed out? The regulatory body has to do what? Go back and do it all over again. Because they are the legislative body for that agency. Inside every administrative agency, there are three parts. Our government has an executive function, which is the president and his cabinet, right? And they're executive agencies. The legislative part is the U.S. Congress, consisting of the House and the Senate. The third party is judiciary, which is the courts, the federal courts, the district, the appellate courts, and the Supreme Court. Federal agencies have exactly the same structure. The commissioners of that agency are the executive body. The rulemaking is the legislative function of that body. And we actually have a court system made up of federal hearing officers and federal judges called administrative law judges that work inside that agency to litigate internal problems with the rules and the regulations of that agency and individuals who come before that agency for having violated one of those. So we have a little governmental body inside an agency that's independent of but works with our government. Investigations are undertaken by the executive branch of government for the agency, the executive, which are the commissioners, right? And they do things like inspections and tests. So if the FDA is looking at a chicken farm, the inspectors work for their scientific arm from within the agency, and they can do inspections as they are empowered by the statute and test what they are required to do under rule. Okay? They can issue subpoenas because there is a judicial branch inside the agency. They issue subpoenas just exactly like a court does with elected judges or appointed judges out in the larger world. They also can issue search warrants. In some cases, they have the power to search and seize property. One place where they have the opportunity to search and seize property is when it's one of the wildlife regulatory agencies. Forest rangers are not called forest rangers, and they don't wear those badges for nothing. Those badges are not for identification. They have police powers. They carry firearms. When something happens out in the backcountry, they are the ones that lead the search or lead the investigation or lead a manhunt if necessary. Because they know their country better than anybody. They're the local police force. So they have the ability to utilize a search warrant from their own agency to find something that is wrong. Like hunters taking game out of season. That sort of thing. Adjudication, the legal function. Negotiated settlements. Negotiated settlements are one thing that the adjudicatory branch can do. They can come into somebody and say, okay, we've got this particular problem that we found. You want to sit down and talk about it and negotiate a settlement, admit that you were wrong, and we can take care of it right now, or do you want to go before the administrative law judge? Formal complaints. They can hear formal complaints, just like at trial. The enforcement arm of the agency has attorneys that work for it that act just like federal prosecutors. In fact, if they work for the federal government, they are federal prosecutors. And they have the same authority as the district attorneys and the federal prosecutors outside the agency. The role of the administrative law judge is to act as a judge. They sit on all legal matters. They hear rulemaking when they go to hearings, either the adjudicated hearings that have interveners or the public hearings. And each matter has its own specific administrative law judge appointed for it. Those judges are tough. Administrative law judges are tough. I was one of them. I spent 5 years as an administrative law judge. I had the same powers as a judge. You earn every penny that you make. They don't make a lot, but you earn every penny of it because it can get really rough.
We know.
Question? Question? Comment? Hearing procedures. Hearing procedures vary from very informal to very formal. Informal hearings are like the public hearings, where all you do is sign up on a sheet of paper, go out, stand behind a microphone, and say what you want to say. The most formal takes the form of a trial, in which court procedure is frequently followed, just like it is in a regular court on the outside, such as federal district court. And then agency orders can be issued by that judge to make an individual comply with the rules of the agency or to perform some action with the agency. There are limitations, however. Information can only be exchanged in formal pleadings in public or open hearings, so that an individual that wants to present something to the administrative law judge or to a commissioner may not do it behind closed doors. It has to be done in public, in the open, and transparent. If it is not, it's what we call ex parte communication, and it can result in the whole matter being thrown out of the adjudicatory phase or the hearing phase, and it can result in attorneys, parties who have intervened, and the judge, if he is involved, in being sanctioned. And that can be monetary, it can be practice time, it can be termination. So we have the administrative law judge. This slide illustrates that they cannot talk to the commissioners directly. Administrative law judges are their own branch of the agency. They can't talk to the commissioners. They also cannot talk to staff counsel or to the consumer counsel, who represents the general public, except when that counsel is presenting matters in open hearing before the general public. And so naturally, the staff counsel and the consumer counsel can't talk to the commissioner's legal advisors, who would then talk to the commissioners either. There are walls put up. These are imaginary walls. Sometimes they're not imaginary walls. Sometimes these individuals actually work on different floors of buildings, and the elevators for those floors do not go to any other floors except in an emergency evacuation. Sometimes they work in separate buildings. We okay with this one? Limitations on agency powers. We have appeal to the courts. We have executive controls and legislative controls. Well, we all understand what appealing a decision to the courts will do. What will that do? It gives a precedent which must be followed then by the agency and by the parties that were involved in the appeal. Executive controls. We talk about executive agencies. Executive controls are directions that a president will give to his staff and to his cabinet. That is his control. He ultimately also controls the pocketbook. And all of the money that goes from the Congress to the agencies to fund their operation. And if he doesn't like what they're doing, and he wants to make sure they stop, he just cuts off their money. And all their staff goes somewhere else because they're not getting paid. Legislative controls. Legislative controls are very similar to executive controls, but we talked about the legislature controlling agencies which are independent. The legislature can cut off the money to an independent agency just like it can to the executive if it wants to cut and throttle the executive's powers. So it controls the appropriations bills, and it will control the operations of various agencies through the money distribution. Public accountability. We have something called the Freedom of Information Act. The Freedom of Information Act makes it possible for any individual, any citizen, to go in and pay for the reproduction of documents and find out exactly what was going on at a certain time or a certain place with an agency. For example, ill. And my daughter wants to make sure that I obtain veterans benefits and am treated in a veterans hospital because it's determined that that's the place for me to be treated. She does not have access to my military records. She can request them under the Freedom of Information Act and can pay for their reproduction and certification and submit them to the Veterans Administration to make sure that I receive proper care. That's the way the Freedom of Information Act works.
What information did you say they can request?
They can request records of any type having to do with the subject matter in which they are interested or in which they have a partial stake. The Sunshine Act. The Sunshine Act, yeah, Miles.
Does that mean that they have to grant you the information?
If it is not classified, they do.
They have to.
Yes. Yes. Information also is only classified for a certain number of years before it has to be put up for classification. So if something about my record was classified and it's been 26 years, then it's automatically declassified, and my daughter has access to that as well. If, however, it's considered to be detrimental to the public to have any of that released, the Secretary of Defense or the President can order it to be reclassified for another 26 years. So anything that is top secret and is classified, that's a further restriction. Just being classified is one thing, to restrict it from the public. But if it's top secret and classified, and somebody manages to get a hold of some of the records, they can only see the ones for which they have a security clearance. Okay? The Sunshine Act, I was starting to talk about that. The Sunshine Act means that everything that has to do with government should be done out in the open. Hold hearings, public's invited in, that's the Sunshine Act. There are only certain exceptions, the most important of which is personnel matters. If the city, we'll say, wants to talk about one of the members of the school board administration, like the head of the schools, and they want to talk about personnel matters having to do with him, they can go behind closed doors. As much as the press would love to have entry into that room, they cannot have it because the Sunshine Act says that employment matters are accepted from public hearing. The Regulatory Flexibility Act. The Regulatory Flexibility Act is one that allows individuals to view records that have been placed on deposit for review by the public specifically. Such as, every now and then, you're watching TV, a local station, and it comes up and says, our renewal for application of our broadcast license has been deposited with the Federal Communications Commission at such and such a file number on such and such a date and is reviewable until some date in the future. And then it lists all the things that it contains by title. Well, the Regulatory Flexibility Act says that anyone can go in and gain access to that. And then the regulatory agency can adapt to whatever it is that the individual is looking for and make other documents available based on that. So that's some sort of regulatory flexibility. Then the Sunset Act. The Sunset Act is part of a law that is put in to make sure that an agency stays relevant. Relevant. The Tennessee Regulatory Authority has a 6-year sunset provision. What happens is every 6 years, the legislature looks at the Tennessee Regulatory Authority and decides, is this agency, 1, doing its job, 2, doing its job the way its statute says it should be doing its job, and 3, is it still useful? If they're answering no to those questions, then it should not be there to draw tax money away from other programs and other agencies that really need it. So the agency essentially is just let to die. And everybody just goes home on one day, locks up the building, and they're no longer a part of that agency. That's what the Sunset Act does. It pushes agencies which are not really necessary for the public good into retirement. Okay? State administrative agencies are just exactly the same as federal agencies. They're parallel in many cases. OSHA, Treasury, tax departments, EPA, departments of energy, the National Guard Bureau is parallel to the Pentagon. There's just all kinds of agencies and governmental state bodies which are just like or similar to federal agencies. There can be conflicts, and if you recall back when we were talking about constitutional law, we talked about preemption. If you do not recall that, please go back and read about that. Because preemption, as you recall, knocks out irrelevant agencies or agencies that have conflicting laws with other agencies at the state or federal level. Go back and review that. This gives you an idea. This is a slide that was in the constitutional section. It shows you that the U.S. Constitution will knock out or preempt the state constitution, concurrent state statutes, and concurrent state regulations. Federal statutes will knock out concurrent state statutes, but not touch the state constitution, and will also knock out concurrent state regulations. And then federal regulations will only kind of butt heads with state regulations that are similar. One of the administrative agencies that we see a lot, and there's a lot of use for, is the environmental law areas of the EPA and the state EPA. Common law actions like nuisance and negligence and strict liability are often cited in these regulations by these agencies. Now, what is nuisance? What's the definition of nuisance?
Is it like something you don't want to do, like anything?
It's something that bothers you. That smokestack is putting out a lot of particulate. That's a nuisance. Diesel engines on certain kinds of trucks, they're nuisances, so we're going to regulate the emissions on those trucks. Just anything that bothers someone. It can be a common law action, and people forget about it when they're suing somebody. They try and sue on a statute, but they forget to put the common law of nuisance in there. Nuisance can be where a body will win their case. Okay? How does it work? Well, first of all, you can't move to the nuisance. If there's a power plant, I know there's a power plant, I know it burns coal, I better not move to the house next door. Because then I can't complain about it. But if I live in a place and somebody builds a power plant next to my house, and I've been there for 30 years and the power plant just gets there, and they're belching out smoke and hurting my health, yeah, I can complain about it. That's a nuisance. And they moved to me. I didn't move to them. Then we always have negligence and strict liability, which we're going to talk about when we get to torts later in the semester. And a tort is a civil wrong. And it allows you to reclaim money and your health and everything that comes in and that you know that you need to have fixed, and puts you back the way you were before you got sick, essentially. And it fits in with common law actions of environmental protection because negligence and strict liability were originally common law solutions. Somebody did something wrong because they made a mistake. Oh, it was their negligence. Yeah. Federal regulation, we have the National Environmental Policy Act of '69, known as NEPA. That is a very broad regulation for environmental invasions. It regulates everything: water, air, land pollution, all of that. Air pollution can be regulated from mobile sources or stationary sources. Mobile sources, automobiles are the big one. We have, in many places, automobile testing. Here in Tennessee, we have automobile testing. They've put it on hold, but metropolitan areas can still test. Stationary sources, of course, are like power plants and industries. And that's covered under NEPA as well. And many state environmental protection laws. Water pollution, navigable waters. This is one which is kind of interesting because navigable waters can be things that you wouldn't even think of. Anybody have a small stream that runs back behind their house or their parents' house or their grandparents' house or down by some place they like to go, like a park? Okay. Is it real deep? About how 6 inches?
Yeah.
That's a navigable waterway.
We keep navigating.
I know. That's the thing. The regulations for the Environmental Protection Agency and for the Corps of Engineers, who regulate navigable waterways, say that anything above 6 inches in depth is a navigable waterway. Yes, I can float my little rubber ducky down that stream, but that's about it. But as long as that little rubber ducky can navigate those waters, that little rubber ducky's a boat. And we're just lucky we don't have to license them. Drinking water, very important. This is where we're having a big problem right now. Think of what happened in Flint. The Environmental Protection Agency is supposed to protect people from that. The state of Michigan and their Environmental Protection Agency was supposed to protect people from lead in the water pipes, but nobody used to think lead was a problem. That's why they used it for water pipes. They were easy to make. But that's wrong. Now that we know about it, we should do something about it, right? Unless what? There's no money. It's hard to work without money. And we can't tell the legislature, unless we vote people in that we want to have in there, where to allocate the monies for these things. So, what's my point here? Vote. Go get the people in there that are going to do the best thing for the community. Ocean dumping. There's an area in the Pacific Ocean that's as big as the state of Texas that is just floating plastic, either on the surface or below the surface. We try to regulate ocean dumping by recycling, and the Environmental Protection Agency does very well with that part of it, but they can't go into international waters unless there's a treaty. Well, some one of you that becomes president or secretary of state or secretary of the Environmental Protection Agency, please go negotiate a treaty that allows international parties to go out and pick up all that plastic and reuse it. That's going to be a gold mine for somebody. Because someday we're going to need plastic, and nobody's going to know where it is, and all you have to do is go, it's in the water, and go out and mine it, just like it was a resource right out of the water. Oil pollution. Oil pollution, you know what oil pollution is. My gosh, we've had some really bad tanker accidents. Remember the one up in Alaska? May have been before you were even born. There was one up in Alaska where the tanker cracked, almost broke in half, and spilled huge amounts of oil on the water. Well, the EPA had to clear that up, and how they did that was they sued the company that owned the oil and recovered the money, and they cleaned up all the wildlife, and they cleaned up the beaches, and they cleaned up the water, and they invented all new kinds of things to clean up all of that disaster. One thing that you might be interested in that might help you at some point is Dawn detergent. Do you know about Dawn detergent? What it does? It will clean the feathers on waterfowl and on clean people, in fact, without removing the oil from their skin or their hair or anything like that. And so they used it to wash all the waterfowl. And then they'd set it aside for a little while. All the water, natural water and oil would come back in because birds preen themselves and they get the oil back, the natural oil back on their feathers. And when they were ready, they put them right back out into the ocean. So that worked really well. They also learned how to vacuum oil out of the ocean. They spread it with kind of like this clay and plastic kind of mix, and then they vacuum it up. And then they take it somewhere and they refine it, just like it was oil from the ground. Toxic chemicals, pesticides and herbicides. Oh my gosh, we got a lot going on with pesticides and herbicides these days. Anybody here use Roundup? Be really
For the
careful
weeds.
around Roundup. It has a really dangerous toxic chemical in it because they think, EPA believes that it is a carcinogen and it acts very rapidly. So please don't use those. Find something natural.
We like vinegar.
Vinegar's good. And there's some natural chemicals. Borax is very good for cleaning. Just things like that. Things like that that are naturally occurring that will dissolve and just go away. The Toxic Substances Control Act of 1976 is supposed to work well on these. It doesn't always, because people aren't enforcing it. Hazardous waste, RCRA, 1976, and the Superfund go together. They are meant to clean up hazardous waste dumps. And they found a lot of places. One of them's here in Tennessee, not far from here, out on the east side of Nashville, which had batteries broken up. Batteries have lead plates in them. They broke those up and they just buried them out there, and it was polluting the river. And people were downstream drinking that water. So they found it and they cleaned it up. But I think Superfund ran out of money some time ago, and that's why they're not doing anything else with it. Then we have radiation for state and local. So we have agencies which will go out and check for radiation in nuclear power plants and in hospitals and other places like that. And they have to, if they have a dump or a disposal site, it has to be a safe site and it has to be disposed of properly. Okay, that's it for today. And I thank you, and I will see you again on Thursday.